The Polluter Pays Principle, PPP, serves as a cornerstone of environmental governance, ensuring that those responsible for environmental degradation bear the financial burden of remediation. Under the relevant environmental statutes of each nation, violators are designated as polluters and subjected to regulatory sanctions, monetary fines, or pollution-related levies enforced by governmental authorities. Continuing this discourse, welcome once again. This is your host, Harshit Simha, bringing you an insightful discussion on From Pollution to Protection, the impact of the Polluter Pays Principle. This principle is extensively implemented to address air pollution, water contamination, and oil spills, holding industries accountable for ecological harm. Through rigorous enforcement of PPP, governments drive industries toward pollution control, ensuring enhanced environmental protection and sustainable industrial practices. Today, we will explore key case studies of environmental violations, underscoring the urgency of implementing stricter regulations at both the national and international levels. The Polluter Pays Principle, PPP, is a cornerstone of environmental policy in India, ensuring that those responsible for environmental degradation bear the costs associated with remediation and prevention. This principle is integral to promoting environmental justice by addressing the equitable distribution of environmental burdens, facilitating access to environmental remedies, and preventing environmental discrimination. Equitable distribution of environmental burdens. PPP mandates that polluters are financially accountable for the harm they cause, thereby preventing the unjust transfer of environmental costs to marginalized communities. By internalizing these costs, industries are incentivized to adopt cleaner technologies, reducing pollution and promoting a fair distribution of environmental responsibilities. The Supreme Court of India, in the Vellore Citizens Welfare Forum vs. Union of India case, underscored that the polluter should bear the remediation costs, reinforcing the principle's role in equitable burden sharing. Access to environmental remedies. The implementation of PPP has enhanced access to environmental justice in India. The establishment of the National Green Tribunal, NGT, provides a specialized forum for addressing environmental grievances, ensuring timely and effective remedies. The NGT has applied PPP in numerous cases, holding polluters accountable and awarding compensation to affected parties, thus facilitating access to justice for vulnerable populations. Preventing environmental discrimination. By enforcing PPP, India aims to prevent environmental discrimination where certain communities disproportionately bear the brunt of pollution. For instance, in the MC Mehta vs. Kamal Nath and Oz case, the Supreme Court applied PPP to hold a private enterprise accountable for ecological damage to the Beas River, emphasizing that economic development should not come at the expense of environmental harm to specific communities. In conclusion, the Polluter Pays Principle plays a pivotal role in advancing environmental justice in India by ensuring fair distribution of environmental responsibilities, enhancing access to remedies, and preventing discriminatory environmental practices. The Kyoto Protocol, adopted in 1997 in Kyoto, Japan, is an international treaty that extended the 1992 United Nations Framework Convention on Climate Change, UNFCCC. It established legally binding obligations for developed countries to reduce their greenhouse gas (GHG) emissions, recognizing that these nations are principally responsible for the current high levels of GHG emissions due to over a century of industrial activity. The protocol introduced specific targets. 37 industrialized countries and the European Community committed to reducing GHG emissions by an average of 5.2% below 1990 levels during the first commitment period from 2008 to 2012. To achieve these targets cost-effectively, the protocol established market-based mechanisms such as international emissions trading, the Clean Development Mechanism, CDM, and joint implementation. Developing countries, including India, were not mandated to reduce emissions under the Kyoto Protocol. India ratified the protocol in 2002, aligning with its principle of common but differentiated responsibilities. This framework acknowledged the varying capabilities and responsibilities of countries in addressing climate change. India actively engaged with the CDM, leveraging it to attract investments in sustainable development projects aimed at reducing emissions. However, concerns were raised regarding the CDM's implementation, including issues related to baseline determination, transaction costs, and equitable carbon pricing. Despite its ambitious goals, the Kyoto Protocol faced challenges. Notably, the United States did not ratify the treaty, and countries like Canada and Japan withdrew or declined to participate in subsequent commitment periods. These developments, coupled with the absence of binding commitments for developing nations, led to criticisms about the protocol's effectiveness in significantly curbing global emissions. The Kyoto Protocol laid the groundwork for future climate agreements, emphasizing the necessity of legally binding commitments and international cooperation in combating climate change. Its legacy influenced subsequent frameworks, including the Paris Agreement, which seeks broader participation and more flexible approaches to global emission reductions. Now we shall discuss some of the major international case study pertaining to polluter-pay principles. The case of Imperial Oil Limited versus Quebec, Minister of the Environment, 2003 SCC 58, is a landmark decision by the Supreme Court of Canada that underscores the application of the Polluter Pays Principle within Canadian environmental law. 1. Background: Imperial Oil Limited operated a petroleum storage facility in Lévis, Quebec, from 1918 until its closure in 1973. Subsequently, the site was sold and redeveloped for residential use. In the late 1990s, significant soil and groundwater contamination were detected, attributed to the site's previous industrial activities. Residents affected by the pollution initiated legal actions against various parties, including the Quebec Ministry of the Environment, alleging negligence in overseeing the site's decontamination. 2. Ministerial order. In response to the contamination, Quebec's Minister of the Environment issued an order under Section 31.42 of the Environment Quality Act, EQA. This order required Imperial Oil to conduct, at its own expense, a comprehensive site characterization study to assess the extent of contamination and propose appropriate remediation measures. The directive was grounded in the Polluter Pays Principle, holding past operators accountable for environmental damage. 3. Legal challenges. Imperial Oil contested the ministerial order, arguing that the minister's prior involvement in supervising earlier decontamination efforts and being named a defendant in related civil lawsuits constituted a conflict of interest, thereby violating procedural fairness. The company asserted that this alleged bias invalidated the order. The Administrative Tribunal of Quebec upheld the minister's directive, but the Superior Court later overturned this decision, siding with Imperial Oil's claims of procedural unfairness. 4. Supreme Court ruling, 2003. The Quebec Court of Appeal reinstated the minister's order, a decision subsequently upheld by the Supreme Court of Canada. The Supreme Court concluded that the minister's actions were administrative rather than judicial, emphasizing that the standards for impartiality differ between these functions. The court determined that the minister was fulfilling a statutory duty to protect the environment, and his prior involvement did not constitute a personal interest or bias that would breach procedural fairness. Consequently, the minister's order was deemed valid, reinforcing the application of the Polluter Pays Principle and affirming the government's authority to mandate environmental remediation from responsible parties. This ruling solidified the precedence of holding polluters accountable for environmental harm and clarified the scope of ministerial authority in environmental governance within Canada. The case of North Fraser Harbour Commission and General Chemical Canada Limited versus Attorney General of British Columbia et al., 2005 SCC 1, is a significant Canadian environmental law decision that underscores the application of the Polluter Pays Principle and the scope of governmental authority in environmental remediation. 1. Site history. From approximately 1920 to the 1980s, a roofing products manufacturing plant operated at 9250 Oak Street in Vancouver, adjacent to the Fraser River. The plant primarily used coal tar as a feedstock until around 1957. During this period, BC Electric, a predecessor of BC Hydro, operated a gas plant in downtown Vancouver and transported its waste coal tar to the Oak Street facility. This practice resulted in significant contamination of the site and the adjacent Fraser River sediments. The North Fraser Harbour Commission, NFHC, became the registered owner of the property, and General Chemical Canada Limited was identified as a responsible party due to its historical operations. 2. Remediation Order. In April 1997, the Deputy Director of Waste Management issued an abatement and pollution prevention order under the Waste Management Act. The order mandated NFHC and General Chemical to undertake comprehensive remediation of the contaminated site, including the removal and proper disposal of contaminated soils and sediments, and to prevent further environmental harm. The order was grounded in the Polluter Pays Principle, holding current and past operators accountable for environmental damage. 3. Legal arguments. NFHC and General Chemical challenged the remediation order, arguing that they were unfairly targeted and that other entities, such as BC Hydro and Canadian Pacific Railway, CPR, also contributed to the contamination and should share in the remediation responsibilities. They contended that the Deputy Director's order was unreasonable and that the Environmental Appeal Board, EAB, erred in upholding it without adequately considering the proportional liability of all parties involved. 4. Supreme Court Decision, 2005. The case progressed through the judicial system, with the British Columbia Court of Appeal affirming the EAB's decision. Subsequently, the Supreme Court of Canada reviewed the matter. On January 20, 2005, the Supreme Court allowed the appeal, siding with the dissenting opinion of Justice Rawls in the Court of Appeal. The court held that the remediation order was unreasonable because it failed to consider the potential liability of other contributors to the contamination, such as BC Hydro and CPR. The decision emphasized the necessity for environmental authorities to assess the proportional responsibility of all parties involved in environmental contamination when issuing remediation orders. This ruling highlighted the complexities of assigning liability in environmental contamination cases and reinforced the importance of equitable responsibility among all contributing parties in accordance with the Polluter Pays Principle. In Bentley v. Gordon, 2005, the Land and Environment Court of New South Wales addressed significant breaches of environmental law concerning the unauthorized destruction of a vulnerable plant species. Offense and its gravity. Between August 1 and December 7, 2001, Hugh Charles Gordon conducted slashing, clearing, and excavation activities on his property in Redhead, within the Lake Macquarie local government area. These actions led to the destruction of numerous specimens of Tetratheca juncta, a species listed as vulnerable under the Threatened Species Conservation Act 1995. Gordon's activities contravened Section 118A(2) of the National Parks and Wildlife Act 1974, NPW Act, which prohibits the unauthorized picking, including destruction, of threatened species. The court highlighted the severity of the environmental harm, noting that the destruction not only eliminated individual plants but also fragmented the habitat, causing detrimental edge effects that altered environmental conditions and further threatened the remaining flora. Reference to previous similar case decisions, the court considered precedents to determine an appropriate sentence. Referring to the earlier decision in AXA T Limited versus Environmental Protection Authority, 1993, the court stated, in the context of the conservation of threatened species further, in Bentley versus BGP Properties T Limited, 2006, NSW Lec 34, the defendant was convicted under Section 118A(2) of the NPW Act for clearing land containing Tetratheca juncta without authorization and was fined $40,000. Similarly, in Garrett vs. Williams 2006-160 GA 115, the defendant was fined for damaging an endangered ecological community. These cases underscore the judiciary's consistent approach in imposing substantial penalties for environmental offenses involving threatened species. National Parks and Wildlife Act 1974, NPW Act. The NPW Act serves as a cornerstone of environmental protection in New South Wales, aiming to conserve nature, including threatened species, populations, and ecological communities. Section 118A(2) specifically prohibits the unauthorized picking of threatened species, with picking encompassing actions such as gathering, cutting, and destroying plants. Violations of this provision are subject to significant penalties, reflecting the Act's intent to deter activities that could harm vulnerable biodiversity. Judgment of the court: Gordon pleaded guilty to the charges. In determining the sentence, the court considered factors including the extent of environmental harm, the defendant's culpability, and the necessity for general deterrence. Emphasizing that environmental offenses warrant substantial penalties to deter potential violators, the court convicted Gordon and imposed a fine of $30,000. This judgment reinforces the principle that individuals causing environmental harm must bear the financial consequences, thereby promoting compliance with environmental laws and the protection of vulnerable species. The Chevron-Texaco pollution case stands as a landmark environmental legal battle, highlighting the complexities of corporate accountability and environmental justice. Offense and its gravity. Between 1964 and 1992, Texaco, which merged with Chevron in 2001, operated extensively in Ecuador's Amazon region. The company was accused of deliberately dumping over 18 billion gallons of toxic wastewater and spilling approximately 17 million gallons of crude oil into unlined pits and local waterways. This led to widespread environmental devastation, contaminating soil and water sources across an estimated 4,400 square kilometers. Local communities reported severe health issues, including increased cancer rates and birth defects, attributing these ailments to prolonged exposure to pollutants. Legal proceedings and judgment. In 1993, a collective lawsuit representing around 30,000 affected residents was initiated against Texaco in the United States. Due to jurisdictional challenges, the case was transferred to Ecuadorian courts in 2003. In 2011, an Ecuadorian court found Chevron liable, ordering the company to pay $8.6 billion in damages, with an additional $860 million mandated for reparations. Chevron contested the ruling, leading to an Ecuadorian appeals court upholding the verdict and increasing the total compensation to $18.2 billion, citing Chevron's failure to issue a public apology. Subsequently, Ecuador's Supreme Court reviewed the case in 2013, affirming Chevron's liability but reducing the damages to $9.5 billion. International arbitration and U.S. court decisions. Chevron pursued legal avenues outside Ecuador, alleging that the judgment was obtained through fraudulent means, including bribery and corruption. In 2014, a U.S. district judge ruled in favor of Chevron, determining that the Ecuadorian verdict was tainted by corrupt practices and therefore unenforceable in the United States. Further, in 2018, the Permanent Court of Arbitration in The Hague sided with Chevron, stating that the Ecuadorian judgment was procured through fraudulent means and violated international obligations. Related legal frameworks. The case underscores the application of the Polluter Pays Principle, PPP, which asserts that those responsible for environmental damage should bear the costs of remediation. While Ecuadorian courts sought to enforce this principle by holding Chevron accountable, international arbitration bodies and U.S. courts challenged the enforcement based on procedural and ethical concerns. Implications and ongoing developments. The Chevron-Texaco case highlights the challenges in holding multinational corporations accountable for environmental harm, especially when legal proceedings span multiple jurisdictions. The affected Ecuadorian communities continue to seek justice, and the case has sparked global discussions on corporate responsibility and environmental protection. Notably, in December 2024, Steven Donziger, the human rights attorney who represented the Ecuadorian plaintiffs, sought a presidential pardon after facing legal repercussions related to his involvement in the case. This protracted legal saga underscores the complexities of environmental litigation and the enduring quest for justice by affected communities. The Volkswagen emissions scandal, often referred to as Dieselgate, emerged in September 2015 when the U.S. Environmental Protection Agency, EPA, issued a notice of violation to Volkswagen Group for contravening the Clean Air Act. The automaker had installed software, known as defeat devices, in approximately 11 million diesel vehicles worldwide, including nearly 500,000 in the United States. This software was designed to detect when a vehicle was undergoing emissions testing and activate full emissions controls during the test. However, during regular driving conditions, these controls were reduced, causing the vehicles to emit nitrogen oxides, NOx, up to 40 times the permissible limits. Gravity of the offense. The ramifications of Volkswagen's actions were profound. The excessive NOx emissions contributed significantly to air pollution, posing serious public health risks, including respiratory issues and environmental degradation. The deliberate deception not only undermined environmental regulations but also eroded public trust in the automotive industry and regulatory bodies. Comparative case reference. A pertinent precedent is the Toyota unintended acceleration case, where Toyota faced allegations of unintended vehicle acceleration leading to accidents. In 2014, Toyota agreed to a $1.2 billion settlement with the U.S. Department of Justice to resolve the issue. While the nature of the misconduct differed, both cases underscore the critical importance of corporate transparency and adherence to safety and environmental regulations. Related legal framework: the primary legislation implicated in the scandal was the U.S. Clean Air Act, which mandates stringent emission standards to safeguard air quality and public health. Volkswagen's use of defeat devices constituted a clear violation of this act. Judicial proceedings and settlements: in response to these violations, Volkswagen faced extensive legal actions across multiple jurisdictions. United States: in 2016, Volkswagen agreed to a civil settlement amounting to $14.7 billion. This encompassed provisions for vehicle buybacks, environmental remediation, and investments in zero-emission vehicle technology. Additionally, the company committed $2.7 billion to an environmental mitigation trust to address the pollution caused by the excessive emissions. United Kingdom: in April 2020, the High Court ruled that Volkswagen had installed defeat devices in vehicles, paving the way for collective legal actions from affected consumers. European Union: the European Court of Justice determined that consumers could pursue legal action against Volkswagen in their respective home countries, facilitating numerous lawsuits across member states. Concluding, the Volkswagen emission scandal serves as a stark reminder of the necessity for stringent regulatory oversight and corporate accountability in environmental stewardship. It has prompted reforms in emissions testing protocols and has heightened awareness regarding environmental compliance within the automotive industry. Polluter Pays Principle, PPP. The PPP, introduced by the Organization for Economic Cooperation and Development, OECD, in 1972, mandates that those responsible for pollution bear the costs of managing it to prevent environmental damage. In India, this principle has been integrated into environmental jurisprudence, holding polluters financially accountable for remediation efforts. India's environmental justice movement has been significantly shaped by the Polluter Pays Principle, PPP, with the rise of 1. Grassroots activism. Local communities in India have been at the forefront of environmental protection, often mobilizing against projects that threaten their ecosystems and livelihoods. A notable example is the resistance against the construction of large dams, where indigenous populations and farmers have protested potential displacement and ecological harm. These movements have been instrumental in bringing environmental concerns to national attention. 2. Public interest litigation, PIL. The 1980s saw the emergence of PIL in India, allowing individuals and groups to seek judicial intervention in matters of public interest, including environmental issues. Pioneered by Justices P.N. Bhagwati and V.R. Krishniya, PIL has expanded access to justice, enabling courts to address environmental degradation proactively. Landmark cases, such as M.C. Mehta vs. Union of India, have led to the enforcement of environmental regulations and the establishment of the PPP in Indian law. 3. Community monitoring. Beyond legal avenues, communities have engaged in monitoring local environmental conditions, reporting violations, and ensuring compliance with environmental standards. This participatory approach empowers citizens to act as watchdogs, fostering a culture of accountability and transparency in environmental governance. Collectively, these elements have fostered a robust framework for environmental justice in India, emphasizing the importance of holding polluters accountable, empowering communities, and utilizing judicial mechanisms to safeguard the environment. The Bhopal Gas Tragedy, which occurred on December 3, 1984, stands as one of history's most devastating industrial disasters. A lethal leak of over 40 tons of methyl isocyanate, MIC, gas from the Union Carbide India Limited, UCIL, pesticide plant in Bhopal, Madhya Pradesh, exposed more than 500,000 residents to toxic fumes. Immediate fatalities numbered at least 3,800, with subsequent estimates indicating a death toll between 15,000 and 20,000. Hundreds of thousands suffered acute and chronic health issues, including respiratory problems, blindness, and neurological disorders. Ongoing impact. Decades later, the repercussions persist. Survivors and their descendants continue to grapple with severe health complications, such as cancer and renal diseases. Environmental contamination remains a pressing concern. Hazardous waste abandoned at the plant site has led to soil and groundwater pollution, affecting local communities' health and livelihoods. Compensation issues. In 1989, Union Carbide Corporation, UCC, settled with the Indian government for $470 million to compensate victims. However, this amount was widely criticized as inadequate, given the disaster's magnitude. Many victims received meager sums, insufficient to cover medical expenses or compensate for lost livelihoods. Efforts to secure additional compensation have faced legal and bureaucratic hurdles. In 2014, the Indian government considered revising the official figures of those affected to provide further compensation, acknowledging the initial underestimation. The Bhopal disaster underscores significant failures in corporate accountability and the implementation of the Polluter Pays Principle in India. The prolonged struggle for adequate compensation and remediation highlights the challenges in holding multinational corporations accountable for environmental and human rights violations. This tragedy serves as a critical case study in the necessity for stringent industrial safety regulations and robust mechanisms to enforce corporate liability. The Indian Council for Enviro-Legal Action vs. Union of India, 1996, is a landmark judgment in Indian environmental law, addressing severe pollution caused by chemical industries in Bichi village, Rajasthan. The case was initiated as a public interest litigation, PIL, by the Indian Council for Enviro-Legal Action, ICELA, an environmental organization, highlighting the detrimental impact of industrial activities on the local environment and communities. Incident. In the mid-1980s, several chemical factories commenced operations in Bichi village without obtaining necessary environmental clearances. These industries primarily produced hazardous chemicals like acid, resulting in the discharge of untreated toxic effluents. This led to extensive contamination of soil and groundwater, rendering agricultural lands barren and causing severe health issues among the villagers. Despite numerous complaints, regulatory authorities failed to take effective action, prompting ICELA to file a writ petition in the Supreme Court in 1989. Key issues identified. 1. Environmental degradation. The unchecked release of toxic waste led to significant environmental harm, including soil infertility and water pollution. 2. Violation of environmental laws. The industries operated without adhering to environmental regulations, lacking proper clearances and effluent treatment facilities. 3. Accountability and liability. Determining the responsibility of the polluting industries for the environmental damage and the subsequent remediation costs. Judgment. On February 13, 1996, the Supreme Court ruled in favor of ICELA, emphasizing the applicability of the Polluter Pays Principle and the precautionary principle. The court held that the polluting industries were absolutely liable for the environmental damage caused and mandated them to cover the costs of remediation. It underscored that economic development must not come at the expense of environmental protection, reinforcing the need for industries to operate responsibly and sustainably. This judgment set a significant precedent in Indian environmental jurisprudence, reinforcing the enforcement of environmental laws and holding industries accountable for ecological harm. The MC Mehta vs. Union of India, 1996, case, commonly known as the Taj Trapezium Case, addressed the environmental degradation of the Taj Mahal due to industrial pollution. Environmental lawyer MC Mehta filed a public interest litigation, PIL, in 1984, highlighting the discoloration and deterioration of the Taj Mahal's white marble caused by emissions from nearby industries and vehicular pollution. Incident. The Taj Mahal, located in Agra, India, faced significant threats from air pollution. Industries within the Taj Trapezium Zone, TTZ, a 10,400 square kilometers area encompassing the monument, were identified as major contributors. These industries emitted sulfur dioxide, which, upon combining with atmospheric moisture, led to acid rain, causing the marble to yellow and degrade. Key issues identified. 1. Environmental impact on heritage. The detrimental effects of industrial emissions on the Taj Mahal's structural integrity and aesthetic value. 2. Industrial pollution. The role of nearby industries, including chemical plants and foundries, in contributing to air pollution through the use of coal and coke. 3. Governmental responsibility. The obligation of authorities to implement measures protecting cultural heritage from environmental harm. While giving the judgment, the court referred to the precedents established in the Enviro-Legal Action and Vellore Citizens Cases, the Supreme Court ordered the Calcutta tanneries to relocate their operations away from populated areas. Additionally, the court mandated that the tanneries pay compensation for the ecological damage they had caused and for the suffering experienced by residents affected by the pollution. Judgment. On December 30, 1996, the Supreme Court ruled in favor of MC Mehta, emphasizing the application of the precautionary principle and the polluter pays principle. The court ordered 292 industries operating within the TTZ to switch from coal, coke to natural gas or relocate outside the zone. Additionally, the ruling mandated the development of a green belt around the Taj Mahal and the relocation of industries to safeguard the monument. The Vellore Citizens Welfare Forum vs. Union of India, 1996, is a landmark judgment in Indian environmental law, addressing industrial pollution caused by tanneries in Tamil Nadu. The Vellore Citizens Welfare Forum, a non-governmental organization, filed a public interest litigation, PIL, under Article 32 of the Indian Constitution, highlighting the severe environmental degradation resulting from the discharge of untreated effluents by tanneries into agricultural lands and water bodies, particularly the Pala River, the primary water source for the region. Incident: the tanneries in Tamil Nadu were discharging untreated sewage into agricultural lands, open lands, and waterways, eventually contaminating the Pala River. A survey by the Tamil Nadu Agricultural University Research Centre indicated that approximately 35,000 hectares of agricultural land had become unfit for cultivation due to this pollution. Key issues identified: 1. Environmental degradation. The unchecked discharge of untreated effluents led to significant soil and water pollution, adversely affecting agriculture and public health. 2. Violation of fundamental rights. The pollution infringed upon the residents' right to a clean and healthy environment, implicating Article 21, Articles 47 and 48A, and Article 51A(g) of the Constitution, which guarantees the right to life and personal liberty. 3. Accountability of industries. Determining the extent of liability of the polluting industries and their obligation to remediate environmental damage. Judgment. The Supreme Court, in its judgment on August 28, 1996, emphasized the applicability of the precautionary principle and the polluter pays principle within the framework of sustainable development. The court held that industries are absolutely liable to compensate for the harm caused by their operations and mandated the establishment of an authority under Section 3(3) of the Environment Protection Act, 1986, to implement these principles and oversee environmental protection efforts. Lastly, the Supreme Court of India held that the precautionary principle and the polluter pays principle have been accepted as part of the law of the land, linking these principles to constitutional protections under Articles 21, 47, 48A, and 51A(g). This case set a significant precedent by integrating international environmental principles into Indian jurisprudence, reinforcing the judiciary's role in balancing economic development with ecological preservation. The MC Mehta vs. Kamal Nath case is a landmark in Indian environmental jurisprudence, underscoring the application of the public trust doctrine and the polluter pays principle. The case revolves around the unauthorized occupation and environmental degradation of ecologically sensitive land along the Bees River by Span Motels Private Limited, a company linked to Kamal Nath, the then Minister of Environment and Forests. Initial ruling, 1997, the Supreme Court took suo motu cognizance of a news article detailing the encroachment by Span Motels on forest land adjacent to the Bees River. The motel had altered the river's course to protect its property, leading to significant ecological damage. In its judgment on December 13, 1996, the court emphasized the applicability of the public trust doctrine, stating that natural resources like rivers and forests are held by the state in trust for public use and cannot be appropriated for private or commercial purposes. The court annulled the lease granted to Span Motels and directed the Himachal Pradesh government to take over the area and restore it to its original condition. Additionally, the motel was ordered to pay compensation for environmental restoration. Show cause notice. Following the initial judgment, the court issued a show cause notice to Span Motels, asking why, in addition to the compensation, exemplary damages should not be imposed for the environmental degradation caused. This notice aimed to determine the extent of punitive measures necessary to deter future violations of environmental laws. Subsequent hearing, 2000. In the hearing on May 12, 2000, the Supreme Court deliberated on the imposition of exemplary damages. The court acknowledged the necessity of a fair trial and due process before imposing punitive fines, emphasizing that such penalties should follow the procedures established by environmental protection laws. Consequently, while upholding the need for compensation for environmental restoration, the court refrained from imposing additional exemplary damages without a proper trial. Final judgment, 2002. On March 15, 2002, the Supreme Court reiterated its earlier stance, emphasizing the importance of adhering to due process in environmental litigation. The court maintained that while environmental protection is paramount, punitive measures must align with the principles of natural justice and statutory provisions. The judgment reinforced the applicability of the public trust doctrine in India, establishing that the state holds natural resources in trust for public use and is duty-bound to protect them against private exploitation. This case set a significant precedent in Indian environmental law, highlighting the judiciary's role in enforcing environmental protection and holding individuals and entities accountable for ecological harm. The Sterlite Industries, India, Limited vs. Union of India, 2013, case is a pivotal judgment in Indian environmental law, addressing the conflict between industrial development and environmental protection. Case background: Sterlite Industries established a copper smelter plant in Tuticorin, Tamil Nadu, after obtaining a no objection certificate from the Tamil Nadu Pollution Control Board, TNPCB, in 1994. Over the years, allegations arose regarding the plant's non-compliance with environmental norms, leading to significant pollution in the surrounding areas. In 2010, the Madras High Court ordered the closure of the plant due to these environmental concerns. Sterlite Industries appealed this decision in the Supreme Court. Key issues identified: 1. Environmental compliance. The primary concern was whether Sterlite Industries adhered to the environmental standards set by the Environment Protection Act, 1986. 2. Public health impact. The plant's emissions were alleged to have caused health issues among local residents, raising questions about the company's adherence to the Air, Prevention and Control of Pollution Act, 1981. 3. Precedents. The case referenced prior judgments emphasizing the Polluter Pays Principle and the necessity for industries to operate without compromising environmental integrity. Notably, the Vellore Citizens Welfare Forum vs. Union of India, 1996, case was considered, where the Supreme Court held industries accountable for environmental degradation. Judgment of the court. On April 2, 2013, the Supreme Court overturned the Madras High Court's order for the plant's closure. The court acknowledged that while Sterlite Industries had committed environmental violations, an outright closure was not warranted. Instead, the court imposed a fine of 100 crore rupees on the company, directing that these funds be utilized for environmental restoration and public health initiatives in the affected areas. The judgment underscored the importance of balancing industrial development with environmental sustainability and mandated stricter compliance with environmental regulations for the plant's continued operation. This is a significant example of the tension between industrial development and environmental protection in India. Established in 1996 in Thoothukudi, Tamil Nadu, the Sterlite Copper Plant, a subsidiary of Vedanta Limited, was one of India's largest copper smelting units. Over the years, the plant faced numerous allegations of environmental violations, including air and water pollution. Offense and its gravity. In March 2013, a significant sulfur dioxide, sulfur dioxide, leak adversely affected thousands of residents, leading to health complications. Despite these incidents, the plant continued operations, exacerbating local discontent. In early 2018, Sterlite announced plans to double its production capacity, intensifying public opposition. Residents feared that increased production would lead to heightened pollution levels, further degrading their health and environment. This culminated in mass protests in May 2018, during which police action resulted in the deaths of 13 individuals and injuries to many others. The gravity of the situation underscored the profound impact of industrial pollution on local communities and raised questions about corporate responsibility and governance. Comparative case reference. A pertinent precedent is the Coca-Cola Plachimada case, 2005, in Kerala, where the company's bottling plant was accused of depleting groundwater and causing environmental harm. The Kerala High Court ruled that the company must cease operations, emphasizing the principle that corporate activities should not infringe upon the rights of local communities to essential resources. Both cases highlight the judiciary's role in balancing industrial interests with environmental and public health concerns. Related legal framework: the operations of the Sterlite plant were governed by several environmental statutes, notably the Water, Prevention and Control of Pollution Act, 1974, and the Air, Prevention and Control of Pollution Act, 1981. These acts empower the Tamil Nadu Pollution Control Board, TNPCB, to monitor and regulate industrial emissions and effluents. Citing violations of these statutes, the TNPCB issued an order on May 23, 2018, directing the permanent closure of the plant. Judicial proceedings and judgment: Vedanta challenged the closure order before the National Green Tribunal, NGT, which, in December 2018, ruled in favor of reopening the plant, deeming the closure unjustified. However, the Tamil Nadu government appealed this decision in the Supreme Court of India. In February 2019, the Supreme Court set aside the NGT's order, effectively reinstating the closure. Subsequent appeals by Vedanta were dismissed by both the Madras High Court in August 2020 and the Supreme Court in March 2024, affirming the state's decision to shut down the plant. Conclusion: the Vedanta Sterlite case underscores the critical importance of environmental compliance and corporate accountability. It serves as a reminder that industrial growth should not come at the expense of environmental sustainability and public well-being. The judiciary's stance in this case reinforces the necessity for industries to operate within the ambit of environmental laws, ensuring that development does not compromise the health and rights of local communities. This case centers on the Visakhapatnam gas leak that occurred on May 7, 2020, at the LG Polymers plant in R.R. Venkatpuram village, Visakhapatnam, Andhra Pradesh. The incident resulted in the tragic loss of 12 lives and adversely affected thousands of residents in the surrounding areas. Incident: in the early hours of May 7, 2020, a significant leak of styrene gas occurred at the LG Polymers facility. Styrene is a hazardous chemical used in the production of polystyrene plastics and resins. The gas leak led to immediate health crises, including respiratory issues, skin irritation, and other symptoms among the local population. The severity of the situation prompted the evacuation of nearby residents and raised substantial concerns about industrial safety protocols. Investigation: in response to the disaster, multiple investigations were initiated. National Green Tribunal, NGT, the NGT took suo motu cognizance of the incident, emphasizing the principle of strict liability for industries engaged in hazardous activities. It directed LG Polymers to deposit an initial amount of 50 crore rupees with the District Magistrate of Visakhapatnam for compensation and environmental remediation. High-powered committee: the Andhra Pradesh government constituted a committee to investigate the causes of the gas leak, assess adherence to safety protocols, evaluate long-term environmental and health impacts, and recommend measures to prevent future incidents. Andhra Pradesh High Court: the High Court ordered the seizure of the LG Polymers plant and directed that the passports of the company's directors not be released without the court's permission, ensuring accountability and preventing potential absconding. Court judgment: the NGT, in its order dated May 8, 2020, underscored the applicability of the strict liability principle, holding LG Polymers accountable for the damage caused by the gas leak. The tribunal's directive to deposit 50 crore rupees was aimed at facilitating immediate relief and initiating environmental restoration efforts. The Supreme Court of India upheld the NGT's order, allowing 30 LG Polymers personnel access to the plant to maintain safety measures, while the Andhra Pradesh High Court continued to oversee the broader legal proceedings. This case serves as a critical reminder of the paramount importance of stringent safety measures in industries handling hazardous substances and reinforces the legal framework holding such entities accountable for lapses resulting in environmental and public health crises. As we conclude this presentation, we trust that you have gained valuable insights into the topic, from pollution to protection, the impact of the Polluter Pays Principle, PPP, and its crucial role in advancing environmental justice. This discussion also encompassed the Kyoto Protocol under the PPP framework, along with significant international case studies of environmental violations, including Imperial Oil Limited vs. Quebec, Canada, 1990. North Fraser Harbour Commission, Canada, 1997. Bentley vs. Gordon, Australia, 2005. Chevron-Texaco Pollution Case, Ecuador, 2011. Volkswagen Emission Scandal, Global, 2015. Further, we examined how the Polluter Pays Principle has catalyzed environmental justice movements in India, highlighting landmark case studies. The discussion began with the most tragic instance of PPP failure, the Bhopal Gas Tragedy, 1984, followed by pivotal judicial interventions such as Indian Council for Enviro-Legal Action vs. Union of India, 1996, MC Mehta vs. Union of India, the Taj Trapezium Case, 1996, Vellore Citizens Welfare Forum vs. Union of India, 1996. Additionally, we explored unique cases of environmental negligence, such as Kamal Nath's case, which set an important precedent for pollution-related liabilities. This was followed by contemporary industrial disputes, including Sterlite Industries vs. Union of India, 2013, the Vedanta Sterlite Case, 2018, LG Polymers India vs. Andhra Pradesh Pollution Control Board, 2020. While this session did not specifically address cases involving the National Green Tribunal, NGT, the diverse lessons drawn from these judicial precedents remain highly relevant to the discourse on PPP enforcement. A future discussion dedicated to NGT-related Polluter Pays Principle cases may be undertaken separately. Despite judicial interventions under PPP, developing countries struggle with the effective enforcement, leaving critical gaps in environmental accountability. Therefore, we invite our viewer to stay engaged with this platform as we delve into the concluding topic of this series, the fall of the Polluter Pays Principle in developing countries. Stay tuned, and we look forward to seeing you all next week. Until then, goodbye.